Prophet Shepherd Bushiri and his wife Mary will be back in court today for the extradition hearing to begin. This comes after the magistrate court in Malawi is dismissed a bid by Prophet Shepherd Bushiri and his wife Mary for the recusal of the presiding officer in the extradition hearing.
We're grateful that the decision has been made and that the matter proceeds, and the Honorable Court is ready to proceed with the hearing of the matter. There's a ruling that is coming on Monday 2 p.m. to that effect. However, our arguments are to the effect that it's a criminal matter, and they argue that it's a civil matter. But we believe that the way the extradition proceedings are premised, these ones stem on criminal proceedings and criminal indications, criminal tests, and or criminal undercurrent for fugitive offenders.
Chief Resident Magistrate Patrick Chirwa says the reason given by Bushiri's lawyers for him to recuse himself could not hold, as they failed to prove beyond reasonable doubt that a magistrate could be biased. Defense lawyer Wapona Kita applied for Chirwa's recusal on Monday, arguing that a case was moved from a previous magistrate, Viva Nyimba, without notifying them on accusations of the granted warrant of arrest for the Bushiris in February, despite previous magistrate Viva Nyimba already indicating that the Bushiris should not be arrested in Malawi. Chirwa says he granted the warrant of arrest because he was the only magistrate available. He said he acted within the law when he transferred the matter to himself, since Magistrate Nyimba reported ill. The extradition hearing was supposed to start but was met with another delay when the magistrate postponed the application for recusal. Reports say Wapona Kita disputed the court's view that the extradition proceedings were a civil matter and not a criminal matter.
Well, he said he will give us a copy of his ruling tomorrow. We'll study it. We don't want to be taken by emotions or something like that. But we'll sit down and look at it and make a decision on the way forward based on our reading of it. There were basically three other preliminary issues which we raised. One is that we wanted the full court record from South Africa to be furnished to us, because we know there is information which we want to use which has been omitted from the extradition request. Then we also wanted the court to decide that the matter is proceeding as a civil matter, not a criminal matter, because they are not here to answer to any criminal offense. And then the third is we had asked the DPP to furnish us with the SADC protocol, a gazetted copy, because as far as we're concerned, yes, the agreement was signed, but it's not binding in Malawi. So those were the issues which we raised with the court. The state has responded. The court says it will give its directions next week on Monday.
What is in our favor at the moment is that we have a bilateral and a regional treaty with Malawi. That is why the minister is now responsible for dealing with that. As I said in the beginning, if that is not the case, then the president must get involved to give the green light. And that can sometimes cause even more delay, because the relation between the two countries are maybe not so well. They don't have treaties. So that is why you have to go up to the level of the president to give the green light. But in this instance, when I was at the NPA, we've also asked for extradition, to Malawi. And, they've granted it to us. I think I'm not a politician, so I don't know what really happens between closed doors. But as you can see from the statement issued by our Minister of Justice, he said that he's very encouraged. There's a good cooperation between the two countries, and hopefully that will not cause a problem.